Hello, and thank you for tuning into the Beyond Hourly podcast, hosted by Bentham IMF. As one of the world's most experienced commercial litigation funders, Bentham IMF has invested nearly 2 decades into providing litigation finance and investment capital to plaintiffs and law firms. We offer law firms and their clients a risk-sharing partnership and a proven record of success as a leading global litigation funder. Episodes of this podcast can be found on our website, www.benthamimf.com. I'm your host today, Jim Batson. I'm the head of Bentham's New York office, where I've been an investment manager and legal counsel since joining the company in 2014. Before joining Bentham, I spent 20 years as a trial lawyer. My role at Bentham involves assessing investment opportunities and serving as a strategic resource for the parties we fund throughout the funding relationship. We're back here today with another short episode featuring a member of our team, Sarah Tsou. Like me, Sarah is an investment manager and legal counsel at Bentham. Sarah, welcome to the Beyond Hourly podcast. Thank you for joining us today.
Thanks, Jim.
Sarah, you joined Bentham in January. Could you tell our listeners a little bit about what you did before coming here?
Sure. So prior to joining Bentham, I was at Kirkland & Ellis for about 12 years in their New York office. And during that time, I focused on IP litigation with a particular focus on patent litigation.
And did you focus on patents of a particular type?
Really all different types. So I think it depended on the time, what time in my practice you're talking about. I think I started off in medical devices, which sort of made sense with my biology background.
Oh.
And then transitioned into more high tech in around the middle of my time at Kirkland. And then by the end, I was working in continuing diverse, technologies, but maybe more of a focus on medical devices and pharmaceuticals again. So coming full circle back to the beginning, if you will.
And I'm sure you're seeing an even broader array of patents in your new role here.
Absolutely.
How did you become aware of litigation finance? And once you became aware, what made you decide to join the industry?
Well, it's funny because it's something I heard about a lot during my practice, and I met with some funders as well. In fact, I think the first funder I met with was Bentham. So, of course, the name recognition was, always on my radar, and it feels a little bit like coming full circle to me. And I think the reason why it was always part of the conversation is because patent cases are just really amenable to funding. They're often notoriously long, notoriously complex, and it takes a lot of patience to get to a good recovery. But once you get there, the recovery can be enormous. So I think that's one reason why it was sort of always in the background for me. When I got really serious about it, it's when I'd seen that many of my former partners had gone into funding, either starting their own shops or going to other funders. And I really started thinking about that as my next step. The thing I liked about it the most was, as a longer term practitioner, I found myself going to trial less and less, being in charge of matters and sort of, it just takes time to get to trial. And I was really starting to get impatient, trying to get to the merits faster. And what I liked about funding is that I knew that I could sort of continue on in some ways using my experience and in a way, assisting and guiding clients, but seeing a much higher volume cases and seeing them at a much higher level and really getting to those merits much faster.
Well, terrific. Yeah, it's funny when you say about patent cases and their suitability for funding. People used to ask me when I first started, in this role, do you focus on certain kind of cases? Are you looking at certain industries and so forth? And what I always told people was it's much more about the economics than it is about the type of case.
Right.
We're looking for strong cases, but what we also need are cases that require a sizable investment. We're looking for at least $1 million, and many of our cases are our investments much more than that. And to do that, we're looking for damages at a certain level.
Right.
And then I explained certain types of cases are more suited to that model than others. And it strikes me that patent's ideal for that because you've got, really expensive experts, sometimes very fact-intensive, heavy analytics in just understanding the underlying technology. But if you're successful, the impact of a patent infringement win can be enormous.
Yeah,
and,
absolutely.
The damages can be high.
Yeah, I agree. In patent cases, you definitely are hitting both sides of the equation there, or both sides of the ratio, if you will. On the one hand, you have potentially enormous costs associated with the long-term litigation. It can take in district court 3+ years to recover, maybe more. On the other hand, once you have a case and you can take it all the way through, if you have the resources to get to the end, the recoveries can be enormous. So I think if you view, which I think it makes sense now that, I've spent some time here,
Yeah.
if you view funding as very simplistically an economic proposition where you have a ratio of expense to reward, and is there enough room there for sharing on both ends? And I think patent cases are a perfect model for that.
Since becoming an investment manager, and it's only been 6 months, but I think that's long enough to ask the question, what's become the most rewarding aspect of the job for you?
I think it's sort of transitioning from an advocacy role to more of a transactional role, in the sense that, on a day-to-day basis, I feel that all my efforts are going towards something positive, bringing a client and a claim and a good law firm and funding all together in one package so that a good claim can either be enabled or progress forward. And to me, it's really rewarding. It's like every minute I spend is going towards a greater goal. And that's just a different type of feeling than in my prior role, though there are some similarities. Another rewarding thing is sort of knowing that my efforts are going to building a company I really believe in, and that it's also very different. On the one, when you're representing clients, you're sort of representing the interests of numerous companies and stakes and interests. But here, after doing my due diligence and looking all over the industry, I decided that Bentham was where I wanted to be and to grow this new practice. And knowing that my efforts are going towards that goal and a company I really believe in is also obviously very rewarding.
I hope it stays that way. I have every expectation that it will. In that vein, what are you able to do now as an investment manager at a funder that you feel like you weren't able to do in private practice?
I think the first thing that comes to mind is just sheer volume and diversity of cases I'm looking at. You mentioned at the beginning that I'm looking at more technology, more diverse technology than I ever saw in my practice, and that's absolutely true. And that's just a function of having the bandwidth to look at so many different matters on a near daily basis. I'm seeing something new and evaluating something new. And I think as a company, we look at probably thousands of matters annually. And I think that, just having a bandwidth to see that sort of diversity is very different, and something it simply isn't possible to do that as a practitioner, nor are practitioners expected to do that. So I think I sort of found that exactly what I was looking for, in the sense that if what I was looking for was getting to those merits faster, I found that this is the way to do it. And it's working.
Yeah, I experienced similar sense as I got more and more into this role. I was a commercial litigator with a relatively niche practice. And as an investment manager here, I'm always struck by the broad array of matters that we see. And then the matters that we tend to delve into are ones where we're dealing with really smart counsel. And it's just, I find it intellectually satisfying to be talking about a variety of different types of cases with really smart people.
Yes.
And really, even though we're playing a critical role, our interests are aligned in that we're trying to see, is this something that can work out?
Right. Absolutely.
Yeah. As you know, patent litigators have embraced funding more readily than litigators focusing on other areas. If I had to say, I would say maybe patent litigation and international arbitration are probably the two areas where litigation funding has, I won't say become entrenched, but become far more common and more broadly understood within those practice areas. Now, what do you think is the driving force behind that? And what do you think other litigators stand to gain by following suit?
Well, I mentioned the long and expensive road to recovery that you often see in a patent or IP case. And that certainly has contributed, I think, to the popularity of funding in that industry. A related driver, I think, is the idea of unlocking value. So patents and other IP can be incredibly valuable, but you have to assert those rights to realize the value. So take, for example, a company that has a patent sitting in their portfolio somewhere that every major player in the industry, all of their competitors are practicing and could be worth hundreds of millions of dollars or more. But that patent's not going to do anything, sitting in that portfolio by itself. Someone has to analyze it, put in resources, find the right attorneys, and assert that patent to enforce the property right and to realize the value of that. And of course, that takes a lot of resources and potentially years and years. So some companies either aren't in the position to do that, or if they are, they're focusing those resources on something else, building their Fortune 100 company or building their small startup. And so they're sort of presented with a dilemma. Do I funnel my resources that I need for my operations into litigation, but now I've left my operations in a lurch? Or do I, keep the resources where they are and where they need to be for the business? And now I've left this value sitting there, not doing anything for me. And the nice thing about funding, I think, is that it's a natural way, and I think it's the way that clients can very clearly understand the funding can unlock that value and sort of release you from that dilemma. You don't have to make a decision, but you can still unlock the value. And the things I've described, the long road to recovery, the costs, and the idea of hidden value that's being unlocked by funding is certainly not unique to the IP context. So, to respond to your question of how other litigators or how other industries can stand to follow suit, I think it's recognizing that these are pretty common things that you can imagine other types of commercial litigation where you have a lot of these similarities and where funding can be equally useful.
Yeah, I find when people that have no understanding of litigation finance ask me what makes it unique or what's the magic behind it, to use a phrase I know you've used sometimes, asking inventors about their inventions and patented product. I really think that at a core, it's that litigation is an asset. And you touched on it when you described unlocking assets, and I was thinking, it's sort of intuitively obvious that patent litigators, and I suspect patent holders, they're already used to the idea that they hold an asset, that a patent is an asset. Well, as you're saying, I guess you unlock the value of that asset by pursuing it, whether it's trying to license it without going to litigation or in many instances having to use litigation to unlock it. And it occurs to me, hearing you give that answer, that really other people can appreciate that their claims, whatever those claims might be, breach of contract, antitrust, who knows, that their claims are an asset. Then the wheels start spinning of the different ways that you could unlock the value of that asset. What types of claims could you bring? Who should you bring them against? How should you pursue them?
Absolutely.
One of the reasons, I know because I've been at Bentham for over 5 years now, one of the reasons we wanted to bring somebody on with your expertise in patent litigation is we recognized that there was this growing demand for funding in the patent space, but that patent cases are a unique breed. They have a lot of unique attributes to them. And, I start hearing things like IPRs and Markman hearings and, infringement and the PTAB, all these concepts that we didn't really understand, not having somebody on staff with, a high level of expertise in that area. Nonetheless, we didn't want to turn away those cases because we knew there were great opportunities there. So we spent a lot of time vetting cases that ultimately turned out not to be, as good value as we had thought they would be, more so than we might have in other cases where we had a greater degree of understanding. But also, I felt like when I was talking to patent litigators and so forth, I didn't really speak their language. And so I didn't feel like we were being as effective. But now having someone with your area of expertise, not only are we better able to evaluate those opportunities, we're also better able to speak to other patent litigators. And that's a long buildup for me to say, can you walk our listeners through sort of the rationale that you look at or the criteria that you look at when you're evaluating a patent case that might be a little different from the criteria that one would generally apply in any commercial litigation?
Sure, but I will say first, you are definitely underselling yourself. We've been on calls together, and I've seen you hold up just as well as any other patent litigator when it comes to these calls. But maybe before I answer your question, I'll share a related thought, which is the idea that it's important as a litigator or as a client pursuing litigation to talk to somebody who speaks their own language is so key. And that's one of the reasons I actually joined Bentham and sort of pursued Bentham versus other funders, because something that really made Bentham stick out in my mind was that every investment manager has at least 10 years of litigation experience. And after spending 12 years in practice myself, I couldn't imagine myself working in a group where that wasn't the case. And I couldn't continue to surround myself with experienced litigators. Of course, it's also true that in some specialties, you want to have some, special expertise, which is why it's so great that, I'm on board now. We have our bankruptcy specialist, our insurance specialist, and our international arbitration specialist. To answer your question, I think first and foremost, we're looking for markers of success. So the thing about patents is you can have a lot of patents, but you don't have to practice them. They may not be valuable. Or you can have patents that are incredibly valuable, and they all sort of look the same. They're a patent that's issued by the U.S. government. And so to really understand which patents are valuable and which are not, you have to look to the impact on the market. So one thing we look to is patents that have been practiced by companies with success, patents that have non-nominal licenses in the marketplace, other indicators of success. You don't need both, but having one or the other is great. We also look to prior litigation history as an indicator of success in the market. So we see a lot of cases where the client or the firm has had some substantial success already. They've overcome IPRs, they've litigated the patent against other defendants, they've obtained good licenses through litigation against other parties. And those are great cases because we're not really testing something that's untested. We're on territory that we know, there's some significant value here, there's market value here.
Sarah, one thing I've learned from you since you've been on board, one of many things I've learned, but one that stuck with me is that in a patent litigation, you could have a great case, a good set of patents, you could bring that case, and then one of the things, if the defendants recognize, we've got exposure here, one of the first things they'll look at, among others, is can we work around the patent that we're asserting against you? And as I understand it, and correct me if I'm wrong, if they're able to work around it, then you could still win the case, but the damages are going to be limited to prior infringement, and you'll lose sort of the ability for damages forward-looking, which many times are the A, more valuable damages, and B, the incentive that the defendant might have to settle the case. So if I've got it right, have I got it right so far?
Yes, perfect.
Okay, great.
I taught you well.
Indeed. So then taking it the next step, can you talk to our listeners a little bit about, generically speaking, are there certain types of industries where that's a greater vulnerability? Again, we're talking in the abstract, versus other types of industries or products where that would be harder for the defendant to pull off?
Sure, absolutely. And first and foremost, when I'm looking at a patent opportunity, one of the first questions that comes to mind is, what is the alternative to infringement? What are some non-infringing alternatives that the defendant can argue would avoid the patent? And there's a couple of reasons that we need to know this. One is exactly the point you hit on, which is if somebody can design around the patent and do it in a commercially acceptable way, there's that risk that they'll do that as soon as the complaint is filed, or they believe that they may be on the hook for future damages, and that wipes out all future damages, and you're left with any pre-filing damages that you may have available to you. That's potentially a bad outcome. But another reason why alternatives are important is because there's, in the patent damages law, a concept of a hypothetical negotiation. And that's the way that you arrive at what a reasonable royalty would have been to license the patent. And that's a measure of damages in patent cases. And one of those factors is, well, if at the time of the first infringement, even if it's pre-filing, there's a hypothetical alternative that the defendant could have used instead of infringing. If they had only known that you would be asking for damages today, and instead of going forward with that infringement, they instead adopted another alternative. Maybe it's an older method of doing things. Maybe it's a new design around that their engineers could come up with. Well, that has the potential to cap the cost of your damages, to cap the amount of your damages at whatever cost it would have taken for them to use that alternative instead. And if the cost is simply flipping a switch and changing one part of the software code, your damages could be pretty limited to just that cost, because why would they pay you millions of dollars if they could have paid some engineers $500,000 or less and spent 1 month on changing that software and customers see no difference whatsoever? So alternatives are very important. And my best experiences are when I'm on the phone with really sophisticated clients and firms that already have the answers to this. And I ask the question only to confirm to myself that they've already thought it through. In terms of what industries this is particularly relevant to, so I've mentioned, software is one where we're always thinking about how easy it would be to design around that feature, in particular because software and other high tech is often part of a really, multi-component type of final product, where even turning it off might be an option, and maybe the customer doesn't see a difference or they don't really notice. So that's an industry where I think it's more important for us to really understand the alternatives. It doesn't mean that they're less valuable patents by any means. It's just something where it's an important question and potentially a hurdle for us that we have to understand. On the flip side, something that comes to mind would be medical devices are the types of potentially infringing products where you have less risk of design around, and that's for a number of reasons. So usually there's fewer components, fewer other components that you can rely upon to sort of solve the problem if you take out the infringing feature. And probably more importantly, there's more regulatory hurdles to getting those products approved. And so once you see a product on the market, it's already gone through a very long process to get there. And there's less risk of them immediately changing the product in a way that makes it non-infringing and getting around the patent, I should say.
Gotcha. Wow. And that's just yet another example of something that without having a patent expert on staff, I would have never appreciated. We wouldn't have appreciated. And, part of our process here, as I know you know, but for the benefit of our listeners, is when we decide we like a case internally, sort of at a preliminary level, we then we don't have to, but we typically engage external counsel to give us an opinion with their level of expertise. And having somebody that understands the issues that you're raising just enables us to cull down to the best cases to look at and spend the time and money on external counsel on those cases and not the others. And quite honestly, that's to the benefit of people who are bringing cases that we don't ultimately fund, because one of the things we pride ourselves in is a quick turnaround.
Yeah.
We want to get them a quick answer, and whether it's positive or negative.
Yeah, exactly.
So what do you foresee as the potential impact of litigation funding on the IP space in the long term? Do you think it'll change the way lawyers structure their retention agreements? Will we see more contingency arrangements, more hybrids, or not? Do you think it'll sort of continue apace?
Well, I think a number of changes come to mind as potentially occurring in the future. So on the contingency front, I do think patent cases and patent funding may drive more and more contingency, because it's one of those types of cases that is sort of a natural fit for that, whether it's from a funding perspective or a law firm perspective. You have this really potentially high recovery where there's plenty to share, and often clients that either cannot or do not want to spend their own money to get to that point.
And isn't it the case too, for patent cases particularly, the ratio between attorney time cost and out-of-pocket cost is greater. So what I mean by that is, in commercial litigation, maybe the ratio is something like 10 to 1. You spend $1 million in fees, you're probably going to have about $100,000 in out-of-pocket expenses. I'm kind of making that number up, making the ratio up, but to make the point. What I see in patent cases is, if you have $10 million in fees, it wouldn't surprise me at all that you got $4 million in out-of-pocket expenses. Mm-hmm. And so it's one thing to say to patent firms, as you're suggesting, and I tend to agree, okay, they're going to take on more contingency, but I think it's another thing to say, and we're going to fund the out-of-pocket expenses. Do you see a synergy there?
Yeah, absolutely. So I agree the cost can be, as I'm finding out, relatively higher in patent cases than in other types of commercial litigation. I only had my own experience prior to joining Bentham, so I thought it'd be normal to have, like a $4 million cost tab for a $10 million litigation. But in fact, it's not. And the reason is because patent cases are so driven by expert analysis.
Yeah,
multiple proceedings, IPRs, potentially parallel ITC cases with their own costs, multiple hearings, and of course, ultimately a long jury trial at the end of the day, if that's where you're trying the case. So the costs go up very quickly. In that situation, one of our major value adds is, even for firms that are able to take on cases on full contingency, they may not be willing to pay the cost. And that's where we can come in and sort of fill in the rest for them and cover a significant part of the litigation expense, including those costs which the firm may not be able to take on their own. In terms of other changes, I think a really important one is, I think funding is going to enable better and better claims to be brought. And on the flip side, serve as a gatekeeper function to prevent those less than meritorious patent cases that we've all heard about and all understand, and prevent those cases from seeing the courthouse. We are basically an added level of diligence that, in my experience, is often much more rigorous than a firm might undertake on its own. And it's only after the case survives both the firm's diligence and our diligence that it's able to access the litigation system. I think that's how it should work, because ultimately it's the more meritorious claims that are able to proceed. And I think that benefits everybody.
Hear, hear. All right, well, last question. What is something interesting or unique about you that our listeners might not know, and that you'd be willing to share with them?
Thanks for the caveat. I write short stories. Yeah, I haven't for a long time, but since I was a kid, was very interested in writing short fiction and took classes in high school and college. And hope to just start that up as a hobby again. But I have a little, stack of stories back home.
Well, hopefully all the unique and interesting cases you see maybe will spark some short stories.
I'm sure they will.
Let me thank you again for appearing on Bentham's Beyond Hourly podcast, Sarah, and for sharing your knowledge and expertise with us. As I mentioned at the outset, episodes of the Bentham Hourly podcast can be found on our website, www.benthamimf.com, and on iTunes, Spotify, Stitcher, and SoundCloud. We'll be back soon with another episode focused on advancements in legal services that drive economic value for law firms and the clients they serve. Until then, I'd like to thank our audience for listening in and invite you to follow up with us with any questions or comments you may have at info@benthamimf.com, or to provide any feedback, ideas, or insights you have on topics you think we should cover on the next podcast. Thank you and be well.